Welcome. Thank you for joining me. Today, we're heading to South Carolina, to the courtroom of Judge Patrick Cleburne Fant III in regards to the rose petal murder in the South Carolina versus Zachary David Hughes for the murder of Christina Parcell. There was a full day qualifying jurors in conducting voir dire. We now have 12 jurors in full alternates. And we're now going to go into pretrial hearing in regards to motions that are left pending before tomorrow, the anticipated start of opening statements. So let's begin.
First, I know that we are going to have, obviously, a media presence, and we welcome you. Our courts are open to the media. I do want to make sure that everyone in the media has received a copy of my order. When we were initially going to trial, I had an order, then I did an amended order, and then, of course, I just did an order for this trial that we're in now. But please make sure that you have that. And again, I welcome you to our courtroom. I do want to just say a couple of things, though. And I think that you all are probably fully aware of this, and this is really for your protection. But you are not to use the name of a minor in any reporting. And also, I have gotten a couple questions, recurring questions about my order. There is going to be a 30-minute delay. And again, I just ask that you abide by that order. I also ask that there not be any reporting on anything for a 30-minute delay consistent with my order. And if anyone does not understand that, just please contact my office or the clerk. Okay? All right. Solicitor?
Your Honor, just one housekeeping matter or matter that we wanted to raise. From the defense perspective, Your Honor, we have no objections to the manner of selection and the composition of the jury, Your Honor. Wanted to raise that with you, but we have no objections.
Yeah, and I appreciate you doing that. That was on my checklist of whether or not y'all had any objections to the selection of the jury. Thank you, Mr. Moorman.
And the state does not have any objection either.
Okay.
The selection of the jury.
So no motions pertaining to the selection of the jury in this matter. Thank y'all. All right. Let me double check. The state had initially filed a motion in limine. Later, the state filed an amended motion in limine. And I think that we will hear that one first.
Yes, Your Honor. The state filed a motion for a gag order specifically regarding the accusations that were alleged by the defense counsel against the victim in this case, Christina Parcell. And it was in conjunction with our motion to exclude evidence relating to the case against Brad Post, who is going to be a witness in this case. Your Honor's familiar with. He's been charged by the state of South Carolina as being prosecuted by the Attorney General's office for sexual exploitation of a minor. That case occurred about 2 weeks. Those charges were brought against Brad Post about 2 weeks after the murder of Christina Parcell, and about the same time that the defendant in this case was charged. And so we filed a motion for a gag order for the purpose of keeping those statements out of the record and out of the press and from reporting on it, because the state felt that it was prejudicial. And it was in conjunction with our motion to exclude evidence of child pornography that is allegedly found on Brad Post. And I say allegedly because Brad Post has not been convicted. He's been charged with sexploitation of a minor first and third, and I believe buggery, based on lots of videos and photographs that were located on his phone and thumb drives and computers. He just happened to be the fiance of Christina Parcell. And so we've asked this judge, your Justice Honor, One, to keep the defense from putting those in their motions. We had put those things in their motions so that that information, which has been unsubstantiated at this point in the trial, at this point in our procedure, and if it was necessary for a filing, to redact it so we could keep it out of the hands of the press and a potential jury. In addition, the state was attempting to comply with the Victims' Rights Act as well, which a victim, in this case, Christina Parcell, has a right not to be shamed and ridiculed in the case against the defendant who's allegedly committed this murder. So that's sort of gone on, and that we filed that back in October, Your Honor. And at this point, the state withdraws that motion for a gag order as we've now picked a jury, and so it's basically moot at this particular time. And then we'd like to move on to hear the exclusion of the child pornography evidence or anything related to the Brad Post case in there for the purposes of this trial. I'd like Your Honor to hear that. I know we've did the motions, and I know you have something to say about the gag order.
Yeah, and just for the record, I am, I mean, you've withdrawn it now, but I would be denying that. And just for the record, I have reviewed Nebraska Press Association versus Stewart, N. Ray Murphy Brown, LLC, State, Rec Co versus State, State versus Price. And again, I would be denying that motion if it was not withdrawn. I also would note the case of ex parte, capital U Drive It, in which it stated, quote, judicial proceedings and court records are presumptively open to the public under the law. And First Amendment of the U.S. Constitution and the state constitution, Article 1, Section 9. I do want to note for the record that at no time has there been any order by any circuit court, any judge here that has ever sealed any of the filings that have been made. It's my understanding, for the record, that the state specifically asked the clerk's office to hold certain filings. And so I just want to make sure that the record's clear and that the clerk will be instructed to make public any filings other than, I mean, I guess the gag order does not need to be filed. Okay. All right. We will move on with your motion, which is your motion in limine, amended motion in limine.
Yes, Your Honor. Yes.
When you're ready to proceed.
Okay. Thank you, Your Honor. Yes. So the state filed a motion, an amended motion in limine to exclude any reference to any evidence of the child pornography. Now, say the alleged child pornography, again, has not been substantiated in any court, as Brad Post has pled not guilty to those cases, to his particular case. All of the items were found on devices in his possession or under his control. And so our first argument, Your Honor, was that in this particular case, in the case of who killed Christina Parcell, Zach Hughes has been charged with that crime. That particular crime that may or may not have been committed by Brad Post has absolutely no relevance to this particular case. And so that's of course our first argument of that. And we highlighted in our motion, Your Honor, the highly prejudicial effect of putting in the fact that child pornography may have been on some of his devices there. And I cite State v. Cooper as well. Evidence which can have no other effect to cast a bare suspicion upon another or raise a conjectural inference that the crime was committed by another is not admissible. But not only is there conjecture, Your Honor, there is absolutely zero relevance to any and all child pornography to this murder case, and there's no nexus, and the defense cannot provide a nexus at this stage in the process. And so, Your Honor, we would ask you to exclude any and all reference to child pornography, which goes to also Brad Post's testimony as well. We've also asked this court to limit the testimony of Brad Post. And for the record, Your Honor, his attorneys asserted a blanket Fifth Amendment protection on his behalf in relation to that. It's my understanding State v. Lawrence is the main case on that as well. And the key to that is that he's not an inculpatory witness. He's at the bottom of the chain when it comes to evidence against Zach Hughes. His testimony will be, I've never even met Zach Hughes. I don't know Zach Hughes or anybody that from in the public. And so Zach Hughes, the name of Zach Hughes will not come out of his mouth other than I don't know who he is. So by allowing impeachment evidence, pursuant to Rule 608 and 609, diving into his current charges, because they're not convictions yet, of a non-inculpatory witness is what State v. Lawrence and others stand for. And so when you have a non-inculpatory witness, your ability to go into their potential impeachment sort of diminishes and it lessens as you go forward. All the other cases that we cited, Your Honor, are folks who were eyewitnesses to crime or they were in the car before a murder happened. In this case, Brad Post is merely just going to talk about how he arrived at her house at around 11 o'clock on the 13th and found her deceased body inside his house, her house, and the house where she lived with her sister and her daughter. So we would ask this court to restrict that any mention of that evidence on those grounds in relation to Brad Post, as well as the impeachment. We would ask this court to limit the impeachment or the conversation about his pending charges to, have you been charged with a crime? Would be the extent you can go into his pending crime now that he's defending against. Otherwise, Your Honor, at the end of the day, going into his particular crime would serve this jury absolutely no purpose as to whether Zach Hughes committed this crime or not. Again, at this stage in the proceedings. So we would ask, Your Honor, that. And we would also ask you to restrict the defense's ability to cross-examine him on that particular area. As, again, it's not relevant and it's extremely prejudicial. And I remind Your Honor, if this jury hears about any child pornography related to the victim in this particular case, you cannot unring that bell. You cannot unring that bell. And it is highly, highly prejudicial to the victim in this case. It is a violation of the Victims' Rights Act unless there is a mechanism and relevance and a path to that evidence at some point in time. And Your Honor, the state believes there is no path to that evidence. There's certainly no path to that evidence at this stage in the game, and before the state has even permitted any or presented any evidence to this jury. And so we certainly would ask, Your Honor, to restrict that. And if you do restrict all of those things, we would ask that we don't need an in-camera proffer of Brad Post. As far as the state's questions, we have gone over those. I've submitted those to the court. I've submitted those to defense. Brad Post has responded to those. He did not assert his Fifth Amendment right on any of the questions that the state begins to ask. And so by allowing the defense counsel to get up here and ask him questions they know he's going to take the fifth on, or in that square box of child pornography related questions, it would really just allow them gratuitous information into the world that has no bearing on this particular case. And so we would ask, Your Honor, there's no reason to have an in-camera hearing and restrict their cross-examination and of course our direct examination to non-child pornography related testimony regarding the defendant and the victim in this case.
Anything else from the state?
Not at this moment.
All right, Mr. Moorman?
Your Honor, may it please the court. First, a timeline I think would be useful. The state moved to exclude this evidence in September of 2024. In November, we had a bond hearing for our client. After the bond hearing, the state instituted the motion for gag order, and sometime around there amended the motion in limine. So, Your Honor, I would argue that timeline, I don't think necessarily they were in conjunction with each other. Your Honor, this I just have to deal with this from the get-go. The state has told Your Honor once again that these allegations related to the child pornography are, quote, wholly unsubstantiated. this is a refrain that we've seen repeatedly in the pleadings from the state. We have made it very clear in our pleadings in response to theirs that we in no way want to discuss this topic irresponsibly, discuss it gratuitously, but over and over again, when the state alleges that it's wholly unsubstantiated, we just have to address that, Your Honor. It is highly substantiated. We have evidence to show that. And as an officer of the court, I've represented that in pleadings. Mr. Moyer has represented that in pleadings. And that evidence exists, and we're prepared to introduce that evidence. But I want to set that straight. That evidence exists. We're prepared to show it and prove it. As it relates to what the ask is in the motion, extraordinary relief they are seeking. 16,000 or more images of child pornography. We have photographs. We have videos. They want Your Honor, without having seen any of it, without having it introduced at trial, any exhibits whatsoever, to categorically exclude 16,000 or more pieces of evidence that we may or may not seek to introduce. So they want Your Honor, again, to, from the bench, without any evidence introduced of any kind, without opening statements, with nothing, they want Your Honor to exclude that evidence.
Mr. Moorman, assuming that that is the case, their point still is, I don't care if you have 45,000 videos, it's still not relevant is what they're saying, if I understand correctly. So and relevant being makes a fact and issue more probable than not. It is highly relevant. We've also, there are cases that discuss relevance in the context of Rule 402. Relevance relates to evidence that helps the jury get at the truth. All right, and I would actually cite State versus Sweat for that proposition, and I can give you a cite on that. But relevance is evidence that assists the trier of fact, in this case, the jury, to get at the heart of the matter, to get at the truth of the case. All right, and the truth of the case, the bases for the relevance in this case are enormous and will become much more clear after the trial starts. And that's one of the reasons why Your Honor should, at a minimum, decline to rule on this issue until the trial starts and Your Honor can see some of the evidence and what the cross-examinations are. But Your Honor, to again, in a vacuum, to exclude this evidence before Your Honor's had a chance to review it, before it's even offered as evidence, I'm not even sure how you do the 403 analysis, right? Because it's such a fact-intensive analysis. The other thing is when the state argues that it talks about prejudicial evidence. Absolutely, every piece of evidence the state seeks to offer against Mr. Hughes, they believe is prejudicial to Mr. Hughes. Every piece of evidence, should we decide to do that, we offer is going to be prejudicial to the state. But it's not unfairly prejudicial. This evidence is not unfairly prejudicial, Your Honor, because this evidence came to pass based on, in no small part, the actions instituted by Brad Post, who was engaged in this illegal conduct with Christina Parcell. So, Your Honor, it's highly relevant. Your Honor, at this time, there was a discussion about the impeachment and the nature of the charges. Oh, I also want to clean up one fact, and then I'm going to turn it over to Mr. Moyer. The state indicated that in the timeline that Ms. Parcell passed, and then a couple weeks later, Mr. Post was charged with violations of South Carolina law. The timeline is this, that Ms. Parcell passed on October the 13th, that there was one warrant for for sexual exploitation of a minor, 3rd degree, obtained by the Greenville County Sheriff's Office on October the 19th. So 6 days. 6 days after law enforcement obtained an arrest warrant for Mr. Post. And they continually obtained warrants after October the 19th, culminating, I believe, on November the 23rd, wherein they obtained an arrest warrant for Mr. Post for criminal sexual conduct with a minor in the 3rd degree. But I just wanted Your Honor to be aware of the fact that 6 days afterwards, the Greenville County Sheriff's Office obtained a warrant
for Brad Post. Now I would defer to Mr. Moyer to talk about cross-examination related to Mr. Post's pending charges and applicable sentences or potential sentences.
May it please the court, Your Honor. So there are really two issues that are associated with this. Is one, should we have an in-camera hearing for Mr. Post? And the second is, what can we ask Mr. Post about his pending charges? So beginning with that first issue, I think we clearly need to have the hearing, Your Honor. The state expressed concern that we don't want Mr. Post just being asked a lot of questions that he's going to plead fifth to. Well, that's exactly why we need to do this outside the presence of the jury, so we know what he's going to plead to fifth to and what he's not. So we're not just stopping every few questions, having to send the jury out and then hash it over. So, we're prepared to ask him the questions. We're prepared to hear what his answers are, and if he's pleading the fifth, and if he's doing so properly, then we can let that lie. But Your Honor needs to be able to vet him, to make sure that he's not pleading the fifth irresponsibly. That is a question that he should answer, then he needs to answer it. So we would ask that we have that hearing tomorrow morning. We think the hearing should last 30 minutes or so. So I think that would be a wise use of the court's time and would save a lot of problems throughout the trial. The second issue, Your Honor, is whether or not the the defense is allowed to cross-examine Mr. Post about his pending charges and about the penalties. And if it please the court, I did prepare we did prepare a memorandum that talks about some of the cases that I'm going to mention now. And Your Honor, just to give you a little background, Bradley Post faces 9 different charges. So he has one charge of criminal sexual conduct with a minor 3rd degree. That charge is violent. It carries up to 15 years in prison, and it carries automatic sex offender registry. He has 5 counts of sexual exploitation of a minor 1st degree. Those charges are violent. They carry sentences that range from minimum of 3 years with no parole to 20 years, and sex offender registry is discretionary. He has 2 counts of sexual exploitation of a minor 3rd degree. Those carry up to 10 years in prison and discretionary sex offender registry. And then he has a charge of buggery that carries prison for up to, that carries a 5-year straight prison sentence with mandatory sex offender registry. Now, Your Honor, the law in South Carolina is crystal clear that the defendant's Sixth Amendment rights are violated if he is not allowed to question a state's witness about pending charges and the penalties. I'm not aware of a single case in South Carolina where the defense was prohibited from cross-examining a state's witness, and on appellate review, it was not ruled to be error. And that goes not only to naming the charges, but to bringing out the penalties. And I'll go over 4 cases very quickly in a minute. But before I do, I think what is especially telling on this point is the fact that the case that the state uses, State v. Smith, is a case in which the Supreme Court ruled that it was error for the defendant not to be able to cross-examine a witness about the charge that was pending against him. In that case, they just mentioned that he had pending charges. The defense was not allowed to go into what the exact charges were, and the Supreme Court said that was error. Now, in that particular case, they found it harmless error, but it was error nonetheless. And there are multiple.
Mr. Moyer.
Yes, sir.
And I know I'm interrupting you.
That's quite all right.
As we go along to ask questions. In that case, the witness, was it someone who was a co-defendant?
Your Honor, in that case, no, it was not. It was someone who testified. He was a victim in the robbery case. He testified about identification of the robber who was the defendant in that case. That person had pending carjacking charges. And actually, in that case, what happened is the state actually dismissed that charge that morning in an attempt to try to keep the defendant from being able to ask about it. The this was actually a PCR case, and Supreme Court ruled that it was deficient of the defense attorney for not pressing that issue and striving to have that charge named. Again, in that particular case, it was found to be harmless. There are a few cases where the courts have found it harmless error. There are many where the courts have overturned convictions, murder convictions. And so basically what you're being asked, it appears, Your Honor, is to just go along with the erroneous ruling, and let's just hope that the Court of Appeals finds it harmless. So so that's State v. Smith. Now there are other cases, Smalls v. State. That is a case where the Supreme Court overturned the conviction because the defense attorney was found deficient for not attempting to impeach the witness with the charge and potential penalty. There's a State v. Gilliam. There, it's a burglary case. There was a co-defendant in that case, and the defendant was prohibited from questioning the co-defendant about the penalty for burglary first degree, which was 15 years to life. And the Court of Appeals found that to be error and overturned that conviction. State v. Mizell. In that case, the defendant was denied permission to question a witness about pending charges and was denied being allowed to ask about potential sentences, and the court overturned that conviction as a violation of the Sixth Amendment. And then State v. Sims, Your Honor. In that case, there was a state's witness testified, had numerous pending charges unrelated to the murder case that was before the court. He had drug charges, grand larceny, robbery charges, and the court ruled that the specific charges could, the trial court said that the specific charges cannot be mentioned, only that he had pending charges, and that was found to be error. So, Your Honor, in this case, I think the law in South Carolina is crystal clear that when a state's witness is cross-examined and he has pending charges, he can be asked about what those charges are and what the penalties are. And so, Your Honor, we would seek to do that.
Does it matter to you that it's the AG's office as opposed to the solicitor?
It's the same party, Your Honor. It's all the state. So that does not make a distinction. It's in the 13th Circuit. It just happens that and I don't think it matters I think the charges could be in Richland County. It could be in North Carolina. What matters is there are pending charges. And the implication is that somebody testifying with pending charges, even if they don't have a deal, in fact, it's even more relevant when they don't have a deal, because the courts have ruled that that person is going to be going out of his or her way to try to ingratiate himself to the prosecution so that down the road, when he or she comes before a court for sentencing, that person can say, Judge, I cooperated with the state. You need to take that into consideration. I testified. And so whether there's a deal or not, whether it's in 13th Circuit or not, whether it's being prosecuted by Mr. Wilkins' office or not, they're pending charges and they need to be asked about.
So that's your argument for 608C bias?
Yes, sir. Not this time. Thank you.
Yes, Your Honor. Briefly, now I'm going to have Mr. Hofferth respond to the Smith case, but Your Honor, this is a simple issue. The defense cannot establish any relevance whatsoever to the case against Brad Post that, number one, I can't give Brad Post any deals because I'm not prosecuting him. So it is very relevant, that issue. But what is on Brad Post's phone has nothing to do with this case, and they still can't establish a nexus to it. They can't establish any relevance to any of that. And until they can do that, there's no reason this jury needs to hear anything about what's going on with Brad Post and his separate crime. Because, Your Honor, whether they like it or not, Brad Post is not on trial here. Zach Hughes is on trial here. And so the fact that Brad Post may have child pornography on his phone really has no place in this courtroom here today. Mr. Hofferth is going to respond to the State v. Smith, and I think it's related to the fact that Mr. Post is not an inculpatory witness, and that's what they keep not wanting to talk about. All the cases that Mr. Moyer is talking about have an eyewitness to a crime, somebody that's very inculpatory to the defendant. Mr. Post is not going to inculpate Mr. Hughes one iota, and therefore your ability to go down a rabbit hole into some pending charges that he's not pled guilty to is limited in that respect.
Thank you, Your Honor, and I'll be as brief as possible, but it's important to start with the foundation here where we're talking about the testimony of Brad Post specifically and the nuance with this case with the backdrop of South Carolina law. I cited Smith and Mitchell in the state's brief because they are the most pointed to the circumstances related to this case, but really the circumstances related to Brad Post's testimony go a step further to warrant the exclusion of such cross-examination as to the sentencing he might potentially be facing, or even the naming of the specific charges. I'll note that the two cases that Mr. Moorman went into great detail on, Gilliam and Mizell, both of those instances are where the witness is charged with the same crimes that the defendant is facing. So obviously that would be probative upon cross-examination to even if there's not a deal in place to pry as to the potential bias of that specific witness. But starting with your ability to tailor this to the specifics of the case, and that comes from the United States versus, I'm going to mispronounce it, but Fredick, F-R-E-I, right? Fredick. It really needs to be a case-by-case analysis. And in Smith and Mitchell, those two witnesses were eyewitnesses, inculpatory witnesses to the crime itself, and then charged with collateral, offenses. In both of those cases, the Supreme Court or the court held that the only essential information that was excluded from cross-examination was defense counsel's latitude in being able to name the specific charges with which that witness was charged with. Not to get into sentencing, not to get into what they were potentially facing, only what the specific charges were. Now, this does also go in conjunction, like most all things in this case, going back to the state's motion and why we filed it with such advance to exclude such mention of child pornography in this case, because we are necessarily eliciting on direct examination that Mr. Post is charged with a crime. Yes, that he is currently in jail. Yes. But as soon as the cross-examination comes out and the question is asked, well, you're charged with criminal sexual exploitation of a minor, that opens Pandora's box in the present case. And of course, looking back to exactly what he's testifying to, he doesn't know who the defendant is. He did not know at the time of the crime, on October 13th, 2021, who the defendant is. He is testifying necessarily because he found the body of Christina Parcell, because he received envelopes going toward the harassment charge of Zachary Hughes. And mind you, he didn't even know who sent those harassment envelopes. And he's testifying to the blanket, to the bare minimum that he was in a relationship with Christina Parcell to explain why he would show up at the house on the morning of the 13th. This is not an individual who says this is Zachary Hughes who committed the murder, who provides any evidence towards attributing Zachary Hughes to committing this murder. So it is completely within your discretion to curtail the cross-examination, to not elicit the charges, but certainly not the sentencing that he faces in opening that door.
And Your Honor, I refer you to 610B. It says cross-examine on any matter relevant to the issue in the case, including credibility. So even the rule contemplates relevancy.
May it please the court. And the relevancy, Your Honor, is bias. And that is a hugely relevant point in any cross-examination. I'd like to read just a little bit from State v. Gilliam. It says, the fact the witness has yet to reach a plea bargain or been found guilty should not prevent the admission of such evidence. The lack of a negotiated plea, if anything, creates a situation where the witness is more likely to engage in biased testimony in order to obtain a future recommendation for leniency. Accordingly, we conclude the Court of Appeals erred in holding the trial judge properly excluded testimony concerning Steele's potential sentence if convicted of the same crime as defendant. Included in the confrontation clause protection is the right to cross-examine any state's witness as the possible sentence faced when there exists a substantial possibility the witness would give biased testimony in an effort to have the solicitor highlight a future court how the witness cooperated. So there's no distinction about whether the person is testifying about something that's inculpatory or not, about what the nature of what the person is testifying is about. And if the state can find any case where it makes that distinction, we would love to see it because it's not there. And because oftentimes we don't know when a person testifies, sometimes it does not become clear how significant that testimony is or what implications are to that testimony until down the road we start hearing from other witnesses. It just comes down to the fact that if it's a bright line rule, if he is pending charges and he testifies for the state, then it can be asked about. And just one other point, Your Honor.
On that case, the witness, it was Page in State versus Gillian?
Let me look at my notes, Your Honor.
Was it a co-defendant? Was it somehow tied in with the crime?
I think Page was a co-defendant in that case.
All right, you had something else?
So what you're, and just with, I think with the Gillian case you had, it was a murder case. He was tried for murder. The murder burglaries. Well, the murder weapon was obtained in a burglary previously that Page, the cooperating witness, participated in. But you know, I would just reiterate what the import of their argument is. Judge, if the witness is really testifying about something that hurts the defendant, then he can be cross-examined on this. But if it's really not that big of a deal, if it's not too inculpatory, then his credibility is not a big deal. There's just not distinctions out there on that. If they put this witness on the stand, this witness has a motivation to curry favor, to get help on his pending charges, then that's open season. That's what the confrontation clause allows. And what Mr. Moyer has said is so true, that case after case after case, trial courts have been reversed when they've sought to limit cross-examination on pending charges and on possible sentences. There's no distinction that we've been able to find in that, period.
You're gonna have a witness up here just asserting the fifth over and over and over, and of course that gets to why you feel like you need to have the in-camera hearing.
And you know,
When the Fifth Amendment and the Sixth Amendment Mr. Moorman.
But Your Honor, there's no conflict here because by saying what he's charged with, that's a matter of public record. By talking about what the possible penalties are, in doing that, he in no way, that's not inculpatory. He says, I know I've been charged with this. I mean, it's like when he's arraigned and they ask him, do you know the nature of your charges and the possible penalties? He says, yes, that's not incriminating. So I would argue there's no conflict here between the Fifth and Sixth Amendment as it relates.
The Fifth trumps.
Right.
The confrontation clause.
If there's a conflict, but if he's asked, what are you charged with and what are the penalties? I just don't see how he can take the Fifth to that.
and Your Honor, we're not getting into where at this point, as we discussed in chambers, at this point, we're not getting into, where this sexual exploitation of a minor came from. I'm not going to be talking about it coming off of his phone or who the victim is or anything like that. Just that he has those pending charges. And as far as the jury knows, these could have been pending from 10 years earlier. There'd be no connection at this point between him and Parcell. It goes to bias. So there's no reason for him to.
But there's no question, it's my understanding, and y'all correct me on this if I'm wrong. Okay, 9/11 will corroborate that he was the one there, correct? The 9/11 call.
I don't know if they plan to play that or not, but.
Yes, we do.
Okay, so to that point, I mean, attacking him on bias when he's telling something that's clearly a fact that even y'all would probably agree to. And then I guess the other things that they plan on getting in with him.
There are multiple things. They're going into these mailings that were sent, having to do the harassment charge. They've already called Bradley Post a victim. So if he's a victim of these mailings, then this gets into implications of our client. So and once again, there's no distinction in any of the cases about what the witness is testifying about, like how damaging it is to our client. It's just the fact that he is testifying. And he has these pending charges.
All right, anything else, Mr. Moore?
Not this time, Your Honor.
This is gonna end.
Okay.
I'll be very brief. I'll just note that where Mr. Moorman is claiming that there's no differentiation, I suppose that ignores the factual analysis that the court goes through on each individual case in describing the pretense to the witness testifying, where the court always makes light of the importance of the witness's testimony. And that's noted in Delaware versus Van Arstal when they are reviewing this for harmless error analysis. And the importance of that particular witness's testimony is, I believe, the first factor that they analyze. And the hypothetical that the state put in its brief, or not the hypothetical, but the reality of when we're talking about what is the impact or the bias value of asking that question from the defense's perspective, given what Mr. Post is testifying to. So you elicit the question, aren't you charged with criminal sexual exploitation of a minor? Does that make the fact that he found her body that morning less likely? Does it make the fact that he received envelopes less likely? Does it make the fact that they were in a relationship less likely? Or what doubt does that cast on those bare factual bases that he's going to provide? And that is the distinction when the courts are analyzing this as to the importance of the witness's testimony to the state's case. He is not sitting there saying Zachary Hughes sent those envelopes. Zachary Hughes committed this murder. Then, of course, where you would get into that same line of cross-examination, of course, that would project bias on the weight of his accusation towards the defendant. But we don't have that here. So that distinction is critical for the courts to take note of. And that's why it is within the trial court's discretion to tailor the scope of cross-examination on a case-by-case basis, depending on what that witness is going to testify to.
And, you know, just very briefly, what Mr. Hofferth was talking about right there, it goes into the analysis of whether it's harmless error or not whether it's error. So it is clearly error not to allow these questions to be asked of the witness. And courts are not supposed to analyze and try to drill down on what exactly the import of this particular evidence is. I mean, otherwise we would have every witness who's testifying for the state who happens to have pending charges. We'd have to have in-camera hearings. How important is this evidence? Is it going to, how damaging is it to the defendant's case? We don't do those analysis. It comes down to a bright line test. Again, is it the state's witness, and does that person have pending charges? And I'll.
Okay. Thank you. I'm gonna take a little while. I'll get y'all a ruling this afternoon. Hopefully I will not take too long. I mean, y'all have done an excellent job on the briefing. So to a certain degree, I've had a heads up on what I need to rule on. So, okay. We will take a break. I can't tell you how long. Hopefully it won't be more than 15, 25 minutes, and then we'll be back.
Okay. Well, the judge stated he would be back. He then muted to make another announcement that he didn't want open court to hear. We are on a 30-minute delay, so they do mute out things that they don't want out in the public. The judge left to make his decision, advising the court that he would be back sometime today. However, the court clerk came in later and said, nope, he'll be giving the decision at 9 a.m. tomorrow morning prior to opening statements at 10 a.m. So, on that concludes this hearing in South Carolina in the Zachary Hughes trial, the homicide of Christina Parcell. In the meantime, don't forget to like, share, subscribe if you haven't already, and hit that bell so you know when we'll be back. Please leave a comment if you like the content or if you have suggestions. We love hearing from you.